speaking to the BBC earlier today. It's an extraordinary case. This guard sentence will be looked at again tomorrow. It cannot be increased, but it could be shortened. I'd love to hear your views on this story. Let's talk to Jeanette Miller. Jeanette is president of the Association of Motor Offence Lawyers and managing director of Jeanette Miller Solicitors. Good afternoon to you.
Good afternoon.
Welcome, Jeanette.
Thank you.
On what grounds can people go for an appeal?
Well, that's the problem we have at this stage of knowing what his grounds are. He has to apply for permission to appeal, and that's obviously been granted. And that doesn't mean that when his grounds are outlined before the Court of Appeal Criminal Division, there will be any change to his sentence. All that means is that there is going to be a hearing to hear why they consider the 9 years to be excessive, although obviously with the circumstances described by the brother of the deceased, I would be surprised if there is a reduction.
I mean, who decides whether an appeal is actually granted?
So when there is a conviction from the Crown Court, there has to be a judge who looks at the application for permission to appeal. So it has already been rubber stamped, I suppose, by a judge for that hearing to take place at the Court of Appeal Criminal Division.
And I guess with any kind of legal case, I mean, the outcome is like to set a precedent for future and any other cases, Jeanette.
I'm not sure it will be a precedent that's going to be of significant use just because of the unusual, I think, circumstances with this particular offender, having had so many previous convictions for exactly the same offending behaviour that ultimately led to somebody losing their life. So I think it certainly sends a message to anybody where there is the use of a mobile phone combined with the cause of serious injury or, in the most extreme circumstances, a fatality. But this particular gentleman with so many previous convictions for that offence, the mobile phone offence, I think is an unusual one.
I mean, if it was a first-time incident, the first time that this guy had been using the phone when he killed Lee Martin, his first offence, even that is not excusable because the law is pretty clear. But the fact that this guy was driving at all, having previously been caught out using his mobile 8 times, is what just it's baffling.
And I'm sure the vast majority of the members of the public are flabbergasted that this gentleman was allowed to carry on driving. We obviously weren't involved in the hearings that took place before the fatal accident or fatal collision, and we don't know what information the court heard about that. But there is a tendency, I think, on the part of offenders, particularly of the mobile phone offence, where there hasn't been an accident, there hasn't been any serious consequence to anybody else. There is this sort of tendency to believe that it's never going to happen to you. And unfortunately, for the family of Mr. Martin, this is something that so clearly could have been avoided had this particular offender taken note of the dangers when previously convicted of the mobile phone offence.
Jeanette, the Martin family were unhappy, clearly unhappy with the 9-year sentence.
Yeah.
Daryl, Mr. Martin's brother, wants the government to change the way these offences are viewed so that they're not in the driving category. Would that make a difference to the term, the length of term someone could be given? So
I'm not quite sure what the family wishes to happen. I know that there have been discussions over some offences where there's unfortunately a fatality being changed to being manslaughter or perhaps even murder. The fact that this is still a driving offence doesn't detract from the very lengthy imprisonment that can be imposed for this offence. 9 years is not the maximum for this. It's actually 14 years. However, I can understand from a family's perspective how it does potentially detract from the seriousness if it is classed as a motoring offence.
Guard sentences, as I say, will be looked at tomorrow. It can't be increased, but it could be shortened. Mm-hmm. Will the court, will anyone take into account what the family of the victim think?
The victim's concerns will already have been taken into account at the original sentencing hearing, and I expect it will again be referred to at the appeal.
It's a fascinating story, this, because these come up, and there are people who lose their lives because of these idiots, and you do struggle to think, well, what does it take to convince people that using a phone, just even for a few seconds, could result in death?
I think, sadly, it's very much a case of until you're in the situation. I'm not a psychologist, but I suspect that there is an element of just not believing that it will ever happen to you. Increases in sentencing for the mobile phone offence itself are planned, and maybe that will have some impact, but there is a generational, I think, concern now over this desire to be constantly connected, whether it's through social media or texting or WhatsApping or whatever it is. But as Mr. Gard now knows, this is something that, the loss of a life is something that he will never, ever be able to reverse. And yeah, I'm sure that had he felt it was ever going to happen to him, then maybe he would have acted differently.
Jeanette, thank you for joining us. Jeanette Miller, President
Pleasure.
of the Association of Motor Offence Lawyers and Managing Director of Jeffrey Miller Solicitors. There were two